this part of the case is the text message exchange that occurred on September the 6th between her and Martin Rivera. That is the evidence that I think is absolutely probative to her state of mind, her mens rea for the commission of the offense, and her claim of reasonableness under the justification.
So are you all abandoning your stipulation that this was in fact her phone?
No, Judge, we are clear. The extraction was done on her phone, and that we're not abandoning that, Judge. I mean, we've agreed that with the state. I told them Cellbrite, the chain of custody of her phone, and the fact that Cellbrite performed the extraction of her phone is not contested, and that we're not. Our theory is not that those text messages were not to her phone or from her. It's I think Mr. Moe is saying there are all these issues with that are there, but to drill into it, it's purely the legal objections to the substance of the text messages and the objections that Mr. Moe made.
And to be clear on my end, Your Honor, I was under the impression that we were just talking about the communications between Ms. Guyger and Mr. Rivera. Now, the proffer has all these other messages. We object to those as not even being remotely relevant to the case and highly prejudicial.
Did you not hear? He said, if we go to the issue of whether or not this is in fact Ms. Guyger's phone, then the state intends to use all of the extraction to prove that, yes, indeed, it was Ms. Guyger's phone. And I heard Mr. Rogers to say, you're not alleging this is not her phone. These are not her text messages, so that they don't have to go to the extremes of authenticating the ownership of the phone and who may or may not have sent the text message.
Right. I just want to drill in, you, Judge, and us, all the parties, on what we're really, if that's the extent of Mr. Hermas's goal is to get those text messages on 9/6 from those time periods. All those objections regarding relevance and the state of mind, all those apply, but we are not saying that it was not her phone and those text messages, couldn't be proven that it was her. We are not contesting that.
Well, then, Your Honor, I stated my intention that I'm going to limit it to September the 6th unless there's some reason not to, and I'll consider that to be an obligation on me in limine, that if I go beyond the 6th, I'll approach the bench.
And you are speaking specifically as it relates to your opening arguments today.
Yes, ma'am. I mean, obviously, first I have to get the court's ruling, obviously. But if the court's ruling is that the text messages and the phone calls that occurred on September the 6th are relevant under 3836, under 404B, then yes, I will include those in my opening statement, and I will limit the testimony and the evidence to that unless something develops that that opens the door to a more expansive view upon, and if so, I will approach the bench.
And I don't want to be so presumptuous, but I am presuming that you do not intend to go into the specificity of the text messages, just that these text messages were going back and forth.
No, ma'am, I was going to go into the specific text messages between Martin Rivera and Ms. Guyger beginning at about 5:55 p.m. It is
So, in essence, do you intend to quote from these text messages?
Yes, ma'am. My intention is to offer those records for the 6th into evidence, and then to quote with the exact time in which they were made, and the exact conversation that goes on between Ms. Guyger and Mr. Rivera.
And do you intend to provide any information concerning the nature of this relationship and the status of these parties?
Yeah, Mr. Rivera is going to testify. Now, I'm going to be very frank with you, Your Honor. I don't plan on going in and going over this information a lot. I plan on covering it in an opening statement. I will proffer for the court that Mr. Rivera has admitted to me that he and Ms. Guyger were in a sexual relationship, and that sexual relationship had begun earlier that year. I anticipate it's going to be his testimony that this was mere flirting or banter between them at the time. I think that's going to be up to the jury to make that decision. The reason why it is so probative for the state, though, is because it shows, if those texts are taken at face value, and Mr. Rivera will admit that there was a text exchange, that there was a plan for later that evening. At 9:30, when Ms. Guyger leaves work, she sends him a Snapchat with a text that says, "Want to touch." That is buttressed by the fact that from 5 until 9:30, they've had exceptionally graphic sexual conversation, which is highly indicative that there was a plan for later that particular evening, which addresses all of the issues that Mr. Gladden talked about earlier, that we expect are going to be raised by the evidence. So it does show that there was a plan, and that's why the phone call that happened 3 minutes and 49 seconds before he died, and actually it was probably a lot less. There was a minute of 3 minutes and 49 seconds between the conclusion of the call with Martin Rivera and when the 911 call was made. Now, I have to guess that she did not have 911 on speed dial the moment she shot Mr. Jean. So there was some time that elapsed between the actual shooting and the call to 911. So it is less than 3 minutes and 49 seconds between that call and with Rivera and the 911 call. And that's why in that particular 3 minutes and 49 seconds, or 3 minutes and 44 seconds, there are repeated instances that the evidence are going to show of unreasonable choices and decisions made by Ms. Guyger. These all go to show her state of mind. So yes, ma'am, to answer your question specifically, I think it is critically important that the jury know that there was a conversation, that it implicates that there was a plan, that there was a call, and that immediately after that call, Ms. Guyger rendered herself inattentive to virtually everything in that 3 minutes and 44 seconds.
Can I see the lawyer you see for just a second? If you've got on an Apple smartwatch, you're not going to be able to wear that anymore. When I say no cell phones, tablets, or laptops, that extends to your wearables as well. So if you got an Apple Watch, don't wear it to this courtroom unless you want me to try to hold on to it until this trial is over. Because what we're not going to have is live texting and commentary, okay? Thank you all. Having read and reviewed and heard your arguments, the court will deny the defense counsel's motion in limine in regards to the text messages and phone calls, web searches of September the 6th, 2018, except as to the relationship status of any of the parties or any of the testifying witnesses. Am I clear?
I'm very clear.
Yes, Your Honor.
Okay. Now, I would very much like to bring the jury inside, swear them in, see if we have any problems or if anybody's had any problems in the meantime where they cannot serve. Take a very short recess, allow you all to make opening arguments after that recess, and begin testimony in this case.
The state has additional, very quick motions we need to put in front of the court.
Okay. Were these filed today?
No, Judge, it's a matter of common practice. It's going to be an oral motion, Your Honor, that the court exclude the family from the role of evidence.
Thank you.
Yes, ma'am.
I'm assuming you do not have any objections to Mr. Don's family members being present during testimony.
Unless they're going to be testifying during the case, Your Honor, we do object to witnesses that will be testifying in the case under Rule 614.
Well, I'm certain that someone from his family will testify that he was a living human being, and you object to that person remaining in the courtroom following their testimony?
I mean, if that's the extent of their testimony and they're excused after that, and they're not going to testify about a fact that's in dispute, then...
Your Honor, we do anticipate the testimony is going to be some biographical information about the complainant, the fact that he was a living, breathing human being prior to this particular event. It is common practice in this county for courts to excuse the family unless there's some finding that their presence in the courtroom after having testified is going to have some material effect on their testimony either before or after. I can tell you I've gotten to know the Jean family very well, and I am more than happy to put them up so that you can inquire as to their character. I have absolutely no reservations whatsoever that any testimony will be affected at all by their presence in this courtroom.
Do you intend to use any member of the immediate family for any other factual issue in this case, other than Mr. Johns having been a living person prior to the events of that evening?
Some marginally, yes, Your Honor, with Miss Finley, his sister. I am going to explore a couple of other matters relevant to Mr. John. In addition to the fact that she had spoke with him that day, he was looking forward to his birthday coming up, that he was obviously loved by his family. There is also one other matter that I think is going to be important when it comes to scene context. There's absolutely no reason.
What context?
Well, so, Your Honor, Mr. John smoked marijuana. I think that probably that was released when the police released evidence of the seizure at his apartment way back when it happened. We're not going to shy away from that, but I do want Miss Finley to explain that is why he used marijuana for that particular purpose, so that there's not an effort on the part to victim shame him, or for the jury to take any kind of adverse.
How is marijuana even relevant?
Okay, I can tell you what, Judge. The inside of well, first of all, I think it's going to be brought up by the defense because of who they have designated as their expert. So I do believe that the defense fully intends on going into that to perhaps suggest that his perception wasn't that of a reasonable person. That's just a guess. Of course, they don't talk. But I certainly expect that that's what they're doing based on how they've disclosed. But secondarily, for me, Your Honor, knowing that that's already coming, I do believe that his apartment, by all of the original responding officers, they indicated that his apartment smelled of marijuana. That is yet another thing that Ms. Guyger completely did not pick up on or failed to allow to register upon her entry into his home where she shot him. Her apartment presumably doesn't smell like marijuana. So again, it goes to all of the facts and circumstances that she rendered herself inattentive to.
So you object to Ms. Finley sitting in during testimony because she will be used as another fact witness for something. Is that correct, Mr. Roger?
I'll play it by, I don't know how far we're gonna go with it, and I guess it just depends if she's testifying about facts and they want to bring her in rebuttal or something like that, and if she's in the courtroom the whole time. Then that's above it, that goes beyond just the normal, hey, we love him, he's a good man, and all that stuff.
So that includes, you do not, I'm just trying to be clear as to your
Right.
objection. You object to any person who's going to provide fact testimony.
Right.
Is that correct?
Yes, sir.
And if I understand you, Mr. Hermes, you intend to use Mrs. John, the defendant's mother, to provide testimony that he was in fact a live person prior to the events of September 6, 2018.
Your Honor, I was going to use Mrs. Finley, his sister.
For both issues?
Yes, ma'am. Miss Allison John, Bo's mom, she would be a rebuttal witness only if something raises the need to call her. And she's a very likely, in the event of a guilty verdict, very likely testifying punishment. I just want to reiterate for the court, I think that the analysis is whether or not their presence in the courtroom will affect their testimony. These folks were not present, so I can't get from them, nor would I even try to get from them, substantive facts of how or what happened inside Bo's apartment that night. But for background information, there's no reason for them to lie about that. And I think that any claim that they're going to materially change their testimony about the biological or biographical information about their son, frankly, I think that's preposterous.
I'm not questioning the biographical information, Judge. I don't know.
I just want to know if you object to their presence in the courtroom or not. They are going to testify.
Not to Mrs. John, because I believe she just purely is a biographical witness. And once Ms. Finley testifies, then I just ask for some latitude to take it up at that time, whether or not she can stay after she testifies.
So you're reserving your objection to Ms. Finley until after you hear her testimony?
Yes, sir.
Do you understand that, Mr. Hermes?
I do
I'll
understand.
conclude, I'll rule on his objection to Ms. Finley if he makes it after Ms. Finley testifies. And as it relates to the other family members, they will not be excluded from the courtroom. And there's a possibility that should we get to punishment, you may use one or more of them. Is that correct?
Yes, ma'am, that's correct.
Are you clear on that, Mr. Rogers?
Yes, Your Honor.
Okay. And the other persons who are present in the courtroom and have an indication that you will be used to testify, you will not be able to be present during the testimony of any other witnesses, nor may you discuss this case with any persons other than the attorneys who are representing each party in this case. So please don't discuss the case in the presence of any other witnesses or with any other persons. Okay, that being said, can we please bring in our jury and try to swear them in and see if we have any problems with any of them serving?
Judge, we have one other issue that came up last night that we're going to bring up on, but it's regard to an interview that Judge Cruzell did with Fox 4 when we discussed this case. And
The one that you had listed in Exhibit 12 of your...
it happened last night.
No, Your Honor, I have
Oh,
the
there was
exhibit.
another interview last night.
Yes, Your
While
Honor.
the gag order was in effect.
I have the exhibit, Your Honor. I was going to put it into the record and bring it to the court's attention.
No, no, fine, no, this... So let me be clear. On last night, the evening prior to the start of this trial, our elected DA did an interview about this trial.
On Fox 4 News, Your Honor, yes. And I have the video and the article from Fox 4 and the screenshot from the data disk. It was short, but it was done, and it appears to be a violation of your order dated January 8, 2019, the restrictions regarding publicity.
Okay. You have the video? Let's see it.
Thanks, Your Honor. Can I approach, Your Honor?
Yes.
All right, I'm tendering to the court, and I've already given copies of these to Mr. Levin, Defendant Exhibit 29, which is a copy of the Fox 4, from the Fox 4 website where the video exists. The very first page of Defendant's 29, Your Honor, is a screenshot showing that the video is there, and then the following pages are the actual printout from the article. Defense Exhibit 30, Your Honor, is a copy of the video that I downloaded from the website, Your Honor, and Defense Exhibit 31 is just a screenshot showing the data that's on the video, showing that simply the only relevant file is 60 megabyte video from that website. That was apparently the interview was taken either yesterday or Saturday. It's unclear, but certainly he's talking about having met the family last week, and he believes the correct charge should still be murder, and he says some other things too. So I want to bring it to the court's attention. Usually the relief on a gag order, it's unclear what the court's relief would be, but we bring it to the court's attention, and then we move to renew our venue motion and move for a mistrial based on the violation of the gag order. We just ask for rulings on those, Your Honor. Thank you. And I ask that those be admitted for record purposes, 29 through 31, defense exhibits.
Your Honor, I have no objection for record.
29 through 31 of the defense exhibits will be admitted for record purposes. I'm going to take a brief recess to go and watch this. In all probability, I will bring our jury panel in and question them individually as to whether or not they view or were aware of this. I'm so curious to know, did you know that this was coming?
Ma'am, I was made aware of that interview this morning by Mr. Mola. I was unaware of it until today.
So where's Mr. Cruzell?
I haven't had a chance to talk to Judge Cruzell this morning, Your Honor.
Curious. All right. Give me 10 minutes to watch this video.
Guyger was initially arrested and charged with manslaughter, but a grand jury indicted her for murder in November. Dallas County District Attorney John Crezeau maintains this is the appropriate charge.
It seemed to me that people were misinterpreting the facts of the case and what they meant legally. And so this issue of manslaughter, that it was manslaughter, I wrote, no, this is more appropriately a murder case based on the facts as reported. And I've studied what we have, and I feel comfortable that we're going forward on it, but I don't have any idea as to how it will end up.
Or watched or heard any of last evening's video?
We have audio only then?
No.
No.
Just, you said you go to the seal?
Yes.
Please go to the seal.
Yes.
Because I don't want, the one question they had for me was to help maintain their anonymity. So, if you know your friend's voice, you know your friend. So no, please no.
Understood, Your Honor.
Thank you so much.
First of all, I didn't get an interview the night before, so let's get that fact straight. And there are lots of other facts about that. So without talking about the case, I was sent an email talking about the recent death of an assistant DA in my office who committed suicide. And journalists had seen me talk about that and seen the emotional impact that it had on me, talking about mental health and the type of jobs that we do and the types of things that we see. So I was asked to do an interview on that. That's what my interview was about. And I was told that's what the story that would air would be about. And I'll leave the rest to your imagination.
Obviously, when you begin yours, you may take down that exhibit and any others that they've left up. Now, are you all going to be ready to begin at 12:30?
Judge, I was ready to go at 8.
Yes, Your Honor.
Promises, promises. Thank you. Now, when you all, if you choose to come back at 12:30, that is absolutely fine, but we are not going to be in and out and in and out. Once you're in, you may only exit during a break. Please, no cell phones, no laptops, no tablets, no wristwatches that you can use to text any of these Inspector Gadget things. Okay? What else?
It's fast, Judge, I promise. I want to offer, for record purposes, only Courts Exhibits 13 through 19. These are a memorialization of the state's adherence to Michael Moore.
No objection.
Those are admitted for record purposes, 13 through 19. Is that correct?
Courts Exhibits 13 through 19, yes, Your Honor.
Okay. And let me just note for the record, the motions and limines that we heard earlier today, your request for them to be sealed, of course, will be sealed. And also let me note for the record that I intend to sequester this jury for the entire pendency of this trial. Yes, Mr. Muller.
May I get the written order Your Honor asked for it on the
Oh,
sealing?
yes.
Yeah, Your Honor.
Yes, sir. Thank you so much.
Thank you, Mike.
Anything else?
I'd like to approach the bench, Your Honor, before you leave. If I could have just 1 minute of your time with Mr. Rogers.
Okay.
That's no bearing on anything at all.
Okay, just for clarity, 12:30, you're gonna bring them in, swear them in, arraign the defendant, opening statement.
I'm